I'm responding to Caitlyn's speech, and her claim was that people who drink and drive should automatically have their license revoked for at least a 1-year minimum following their arrest, and that the current laws are too minimal. Well, I don't think there's any dispute that tragedies continue to exist with people who are drinking and driving. But my claim here is that the fault is not in the law, it is instead due to the people's unwillingness to see the tragedies that come from drinking and driving before they decide to do it. Her claims that she used were that the accidents are very deadly, the trials are too long, there needs to be stricter punishments, and their licenses need to be revoked so that they can help save lives. So her first claim was that the DUI accidents are the most deadly amongst accidents. According to the California DMV website, the biggest proportion of crash fatalities comes from alcohol-related issues, which is 39% of the crashes that occur in California alone. This fact has remained unchanged over the last 4 years, and however, the implementation of this 1-year license removal will not affect the number of accidents that happen, affect the number of crashes that happen, because 78% of the offenders, according to the DMV reports, are first-time offenders. So having their licenses revoked before that wouldn't prevent a majority of the crashes. And after the crashes, the California law also mandates that their licenses will be suspended after the incident anyways. So her second point was that the time period from the arresting of the offender to the sentencing of the offender is too long, and most courthouses are backed up. I don't think there's any doubt that the court cases and trials take a while, but due to a recent California Assembly bill, the DMV must establish and maintain a database that monitors programs for people who are convicted. And this has led to many of improvements for the California DUI system, from tracking DUI offenders to identifying some of the cases that were dismissed that shouldn't have been. And this also allows for the state to be able to keep an eye on the courts to make sure that they're doing what they need to be doing to not get so backed up. And then her third point was that there needs to be stricter punishment for people who get arrested. And then the evidence that she used for this point was about how basically that too many people are getting away with committing DUIs, but many people around the world get away with breaking laws like every day. Like, I'm sure most of the people in here have like been speeding and like not gotten caught every single time. And so, according to Rich Stem, a California DUI attorney, the current laws here in California to be considered a DUI is that a person over 21 and over cannot have a blood alcohol concentration of above 0.08 or higher, and a person under 21 cannot have a blood alcohol concentration of 0.01. If caught, the consequences depend on which offense it is. So if it's someone's first offense, then they can have jail for up to 6 months, fines up to $1,000, and up to a 10-month license suspension with the installation of the ignition interlock device. These charges continue to increase depending on which offense it is. And then when it's someone's fourth offense, it's considered a felony at that point, and they'll be in jail for 16 months with fines up to $18,000 and a 4-year license suspension. And these laws have been continuously changing over the last 20 years to help decrease the amount of DUI arrests. And they've started to see a decrease with the DUI arrests due to these stricter punishments. Her last point was that DUI offenders should have their licenses taken away to help them learn from their mistakes and to help save lives. However, the convicted DUI offenders, according to 2012, DUI offenders arrested in 2012, according to the California DMV, 74% of them were first-time offenders, while only 26% were repeat offenders. According to these numbers, the repeat offenders have, been decreased 10% over the last 15 years here in California due to the implementation of some of these laws. And a majority of the DUI arrests were from first-time offenders, not the repeat offenders. Therefore, you can see that a lot of people have learned from the mistakes that they had, and more people need to be reached to the first-time offenders before they decide to do it. And a program that was done at my high school and many others was every 15 minutes, which is a school-based alcohol prevention program that tries to reduce the amount of alcohol and the consequences of drunk driving. And it makes students and younger generations of people realize the dangers that can come from it. And after watching the simulation, students are less likely to drive when drinking, choose not to drink, or have a designated driver. So in conclusion, it's not the laws that need to be changed to get people to stop drinking and driving. Rather, it's the people who need to have their mindset changed so they too can see the horrible signs and things that come from drinking while under the influence. Thank you.
Okay, well, you do have a preview of what the supporting structure is going to be, and then there's a little bit of inconsistency about signposting as you go along. And sometimes you signpost a counterclaim that you're presenting, and sometimes it's a claim that the advocate's presenting. So that got occasionally confusing. But I thought you explained a lot of your argument. I don't know why you bothered talking about what the number of accidents is, or what percentage of accidents are related to alcohol consumption. It sounds like both you and the advocate agree that it's a lot, and that there's a substantial amount there. The argument that says most of these people are first-time offenders, I thought that was a good argument to be making, and that supports the position that you're taking, that it's really not going to make much of a difference if we do impose that, because it's only after the fact in the situation of those offenders, at least. So at least in three-quarters of the cases, it wouldn't be applicable. So that's a reasonable argument to be making there. The notion that people are already getting their licenses suspended, I think that you need to emphasize that a little bit more, because the advocate seems to be suggesting or treating these punishments as if they don't exist, and I think that's the main point of contention, that this kind of punishment already exists, it's already being imposed, and the idea that the courts aren't doing enough seems to assume that these rules aren't being followed. And did the advocate provide any evidence that those rules aren't being followed? You can demonstrate that the rules exist. I do think you need a source cite on that. You did have one later on talking about what the penalties would be. That was on the third point, and you did have a source citation on that, but like I said, I think it needed to come back later. The argument about backup in the courts, I think you've got an okay claim on that says we got new programs that are designed to monitor and help all this. That's a pretty good response. That's an argument that would be appropriate, for instance, in a policy argument that says the present system is capable of addressing this issue. I'm not sure that it disputes the point that the advocate's making, but the advocate brought up that issue, and I'm not sure that it's relevant to the point that they're making either. So at least you've given an answer to that particular issue. The punishment issue is the thing that I think needs a little bit more development. I think that you need to show that the punishments have changed over time, that they are making a difference, that the idea that we have insufficient punishment seems to ignore the reality that we do have the very punishment the advocate talked about. Okay, maybe there's a 2-month difference. You can get your license suspended for 10 months, and the advocate's talking about a year. So is there a substantial difference in adding those extra 2 months on? That's what the advocate's burden would have to be, to show that those extra 2 months are the thing that would make a difference. And then I think you could argue that there's no reason to believe that it would be any more effective than the punishment that we currently have available. And I thought that you we went back to that evidence that you said that most of the first-time offenders, there's clearly much less repeat offending that goes on. I think there's some degree of that. I think you had a statistic that suggested that we've had a decline over the last number of 15 years. That's a pretty good argument, and it seems to suggest that we're not ignoring the issue, which is the advocate's inference there. Like I said, I thought that the signposting got a little bit confusing sometimes, but a lot of the issues that you talk about, I think you explained them reasonably well. Thank you.